everyone, and welcome to Legal Diagnosis, the podcast where law meets healthcare. I'm Liz Sullivan, the chair of McDonald Hopkins Healthcare Practice Group, and McDonald Hopkins is a law firm that has been serving the healthcare provider client base for more than 50 years. I'm so pleased to be joined today by two senior members of our healthcare practice group, and if you watched our first episode, then you will recognize them, Jane Pinewood and Emily Johnson. A little bit more about each of them. Jane has been counseling healthcare clients on regulatory and business matters for more than 30 years, first as a partner here at McDonald Hopkins, then serving as Chief Legal Officer for BioReference Labs. And finally, we have the pleasure of welcoming Jane back just last year. Emily is a member of the healthcare practice group and a partner here at McDonald Hopkins. She maintains a robust healthcare, regulatory, and business counseling practice, including but not limited to advising on fraud, waste, and abuse laws, as well as business arrangements within the healthcare industry. She also has significant experience with HIPAA compliance, including breach response and notification. And prior to joining MH, Emily served as a healthcare attorney and senior consultant at a national legal-based healthcare management firm, as well as outside counsel for the National Association of Boards of Pharmacy. So each podcast, we are going to be breaking down the legal pulse of healthcare in different areas of the industry, trying to focus on what's new, what's next, and what you need to know. In just about 20 to 30 minutes, we'll cover hot topics, compliance headaches, or regulatory shifts that we see shaping the field. Plus, we'll be joined by legal pros, healthcare insiders, and industry leaders who bring real-world insight to the table. So today we're going to be discussing a topic that is near and dear, I think, to the three of us. And that's really the top themes that we observed during the 2025 Executive War College in New Orleans at the end of April. For those that might not be familiar with the EWC, as it's referred to, it's one of the largest conferences that is focused on clinical laboratory and pathology groups. And it's really unique in that the presentations aren't as much clinically focused, but they're really instead focused on operational and management themes that are resonant within leadership for these types of providers and organizations. So it really brings together executive level leadership and many different industry stakeholders. And as a result, what we find is that it offers really unique and dynamic insights for lab and pathology groups. So with that, we're going to get started and highlight some of the themes that we saw there. So Jane, Emily, what are the top themes that you observed at EWC this year?
Liz, I think one of them was AI. AI was throughout the conference. Now, we all recognize that AI is not a specifically defined term, but throughout most presentations, there was a discussion of some type of technology and AI utilization, and it hit many different areas. Pervasive throughout the conference was a discussion of AI in terms of innovation in the laboratory and pathology industry, how AI may be used to help collate data and move forward technology and developments utilizing these huge data sets that would be too much for any individual to go through, but AI can help facilitate that. And there was a lot of discussion of the use of AI as a tool for pathology. One presentation in particular that was very well received, and I heard a lot of discussion in the hallways about, was Dr. Michael LaPosada's discussion of an AI-assisted tool that is utilized by the University of Texas Medical Branch to assist with pathology clinical consultations. So what Dr. LaPosada and his team at UTMB have developed over a course of many years with a grant that had come from a community benefactor is an AI tool. And I think we really need to talk about this as a tool in a few minutes, but an AI tool that would assist pathologists when they get a request for a clinical consultation. And these are the requests where a clinician is going to ask the pathologist to review the patient's entire medical record, review the applicable literature, review the slides, imaging studies, anything else tied to the patient, and to assist in trying to focus upon potential diagnoses for the patient. These are going to be difficult case situations. These are not the easy ones. These are the ones where the clinicians are typically, running up short on trying to find what's wrong with the patient. Given the amount of data that needs to be culled through, Dr. La Posada and his team have developed an incredible AI tool that's going to tap into the EMR, such as Epic, pull all the information on the patient, anything that's in the medical record, any imaging studies, lab results, etc. It's also going to tap into up-to-date literature, the scientific literature. In addition, they are also constantly curating their AI tool to make sure that it is relatively free of any, I'd say, defects or other maybe Trojan horses or other problems that may be contaminating the data source. And then, much like one would use ChatGPT, this tool will then put together a proposed clinical diagnosis, clinical consultative diagnosis and rationale regarding the patient. It can even generate a letter as well to the clinician and even a letter to the patient. If one has put in the patient's reading level and background, that patient might be able to understand. The important point from Dr. La Posada, as well as our point, as Liz, Emily, and I have discussed it from a legal standpoint, is that these are tools. This is a physician service. It's a professional service. So it is important that whatever a physician utilizes as a tool to come up with a professional diagnosis, that the physician is reviewing it, vetting it, making certain that the physician is comfortable modifying the proposed language as put together by the AI tool to make sure it is accurate and appropriate, and recognizing that when the physician signs out the report, the physician is signing out that report as the physician's professional medical interpretation. It is a professional service. And I think that's an area where there was a lot of discussion and touching upon during the meeting, which is, as we talk about AI, whether it's in medicine, whether it's in law or other areas, this is a tool to assist professionals, but it doesn't replace the professional interpretation service. But it was an intriguing presentation and certainly fascinating for those in the audience to see how the AI could assist in generating a much more robust clinical consultation and taking into account a lot more information than any one individual really has the capacity to review and collate.
Yeah, I mean, I totally agree with you, Jane. I was just fascinated by it. I mean, one of the things that came to mind as you were describing it, and certainly while we were watching the presentation, and this is something I think, Emily, you've actually quoted in the past, the amount of healthcare data is like doubling, every month or 2 months or something along those lines, right? It's something along those lines, Emily. And so how could one physician in any particular specialty, they're an expert in a particular specialty, I mean, how could you knit that all together? So in some ways, I think AI does, certainly from the legal perspective, I think we're always cautious about new technologies, but I think the idea that it can be a tool, a support to professional decision making and professional judgment is exciting.
And I don't, the general consensus I got from talking to folks is exactly that. I don't think there is an intent, at least not by the medical community, the providers themselves, to ever have AI replace clinical decision making. That it is meant to be just a supplemental tool. And I think that's a concern that consumers and patients raise all the time, is they don't want decisions being made by, a computer. So will the practice of medicine lose that personal touch? And I don't think it will, or at least I'm cautiously optimistic that there will still be humans involved. We won't have, robot nurses coming in and doing all of the work.
Yeah. And I thought, other discussions around the application of AI or even just automated systems, within billing, or to take large amounts of data and sort of track trends with denials or those sorts of things. I mean, I think we've known that it existed for a long time. I mean, I can certainly think back many years when we talked about the fact that we thought that would be how, payer audits, how they were identifying folks, maybe not AI, but using that data. And so now to think that AI is a potential tool to help speed up the process of, bringing that data together, identifying trends, I think that's going to be so beneficial now to the provider side from a billing standpoint, and not just something that, it's not just accessible to payers and to government auditors. So I thought that
Certainly. There was a lot of interest in some of the RCM presentations where there was a lot of discussion about how AI can assist with the RCM process.
Yeah. So I thought it was fascinating. And I guess the next thing that it really brings up, I think, from our perspective and something that we talked about when we were preparing for this discussion is data. It's just putting a heavier emphasis on data. So Emily, I don't know if you want to talk about some of the other themes that we saw surrounding data.
Yeah, so I think when you start talking about AI and leveraging the value of AI and the data that it creates, it automatically generates buzz into what is that data and what data do we have and what can we do with that data. So I think a general theme that I noticed at the War College was folks talking about the use of their data, whether it's by them or by vendors, and the ability to monetize data. And it's an interesting idea, but one that should not be sort of taken into consideration without giving deference to the regulatory framework, right, that surrounds how you can actually use data. So, the very foundation, we still have to be concerned about, okay, we're generating all of this new data and it's in this environment. Is it secure? Is it subject to, an attack, a business email compromise, a ransomware attack? But then once you get past that sort of security level of things, who have you given access rights to for your data? Who can get in and use your data? If they have access rights, are they able to de-identify your data, aggregate it with other data? And then the next question becomes, who owns that data if folks are able to actually do that? So it brings up not just privacy considerations, but also intellectual property and ownership considerations as well. One thing that the three of us have kicked around a lot is historically, sort of these IT contracts, folks just kind of signed them because they didn't think that they were very negotiable, sort of boilerplate provisions. And that couldn't be further from the truth right now. It is really important to go through those contracts and make sure you realize as a provider or even as a vendor, what rights you're signing away and who you're giving them to. And then, what sort of rights do you have to audit folks who have access to your records or stop them from using your data without your permission. So I think when we gave that speech, Liz, there was also to kind of layer on this misconception that, okay, we have all this data, we can go out and sell it, like just this raw data, we can just sell it to anybody. And that really isn't true. And I think that point was hammered home in some of the discussions we had with the technology vendors, that raw data, whether you're giving it to pharma or someone else, actually isn't that useful. It has to be refined and sort of cultivated with tools that these tech vendors have to make it something that pharma can actually take action with or somebody else. So I think we spent time sort of trying to right the ship there on that misconception. But I do know, there is a lot of buzz out there about what we can either do independently in the lab space or even in the digital pathology space, or together, like come together to try and leverage the value of our data.
And I think, Emily, to follow up on that, a very good take-home message was that those with these great stores of data need to very much focus upon what do the potential purchasers want and what's going to be of use to them. Because like any asset, you have to be able to position it for potential purchasers and show them the value in the data set.
Yep, I think that's a great point.
Yeah. I agree with you both. I mean, what I thought about a lot from that was the idea that yes, there is so much data and it's almost intertwined between this idea of AI and what AI may be able to do in the sense of pulling together information and organizing it. Because I think we heard over and over again that in many instances there may be rich data, but it's really not easily accessible. There's not an automated way to sort of pull it together and organize it. And it's going to take somebody to do it, or it's going to take a tool to do it. And so anybody who's thinking about, looking at their data and doing sort of, Jane, what you were talking about, which is sort of like, here's the value and here's what a potential buyer might be interested in, they're going to have to do that work and they're going to have to clean it up, so to speak, or, moving forward, start a new process where you're sort of organizing it in a specific and intentional way, or a way that you're going to be able to pull it together, because older information is just going to be, it may not be kept in sort of a consistent manner that's uniform, that's easy to utilize or provide to a potential buyer.
Yeah, to piggyback on that, this idea of external monetization versus internal monetization, I think, is important. You can use your data to reduce inefficiencies and reduce costs as a result of that. And to your point, Liz, you and Crystal and I have talked about this from a deal flow perspective. When you have bad data storage policies at your organization, and that's your data sort of commingled. And we talked about this in like the hospital setting, when outreach data is commingled with outpatient data. So you can't really tell which revenue is attributed to which. That really makes the process of valuation for purposes of a transaction really, really difficult. And also makes like the cap table for purposes of determining like what what is the term that Crystal always uses? The net working capital. To determine the net working capital that has to be available at closing, when that data is commingled, determining that amount is really, really difficult and can frustrate the transaction process and impact the value of the deal.
Yeah. And I guess the last thing I would say as we're thinking through data generally is that it's so interesting to see how much of a discussion this is now. And it's sort of, I think there's a real benefit to the fact there's dialogue around it. I think for a long time, healthcare data and the idea of sharing it and potentially profiting off it was so taboo. And I think that's changed a bit. But I would also say, I think with all of us here as healthcare compliance attorneys, that it's just a reminder that this data still needs to be appropriately de-identified or released with an appropriate authorization in most instances. So don't forget that part of it. We didn't spend a lot of time talking about that, but yeah, that's sort of a basic assumption, I guess, in the discussion that we were having. So I don't know if either of you want to add to that, but I thought I'd be remiss if I didn't at least put that in there. One more disclaimer.
Well, that's a good point.
So yeah, I think you are both right on with innovation and AI and data. Those were, just huge themes. Something else that I certainly felt was a theme this year was enforcement. But the focus of enforcement, from my perspective, was a little bit different than in years past. I think the past few years, well, really more than a few years, but coming off of COVID, I think there was a lot of discussion and buzz, maybe not even in all of the sessions, but essentially, in talking to folks that were there was a lot of talk about enforcement actions, whether those related to COVID testing and reimbursement, or sales practices and those sorts of things, whether it was related to ACRA or anti-kickback and just the way the sales arrangements were set up with sales reps. And other types of business arrangements between, two entities that might be sending one another business. But this year, I thought there was a resurgence in discussions around payer audits. And really, when we think about enforcement, yes, there is Department of Justice investigations where you have sort of the prosecutors looking at anti-kickback, not medically necessary testing or false claims issues with billing. or the OIG taking issue with a particular business practice. But the other part of enforcement that, has historically been a very active area is payer audits, whether we're talking about government payers or commercial payers. And I thought there was a real resurgence in clinical labs and pathology groups experiencing audits. I think during COVID, that process was very much disrupted with people not in the office. All of those payer investigation units had to go remote. And I think it really did disrupt the cadence of the audits. But I think what we're seeing is really a resurgence in payer audits, whether we're talking about commercial payer audits or we're talking about government payer audits. And I would say, there's always the potential for a lab or a pathology group to experience an audit, but overarching themes would be, different types of molecular testing. Urine PCR in particular is something that we've seen a lot of audit activity recently with clients. I think there are still a number of COVID-related audits that are out there, and we may still continue to see those just because of the need for investigation, how long it can take for an investigation. I would say on the audit side, I don't know that it's so much audits on COVID, but maybe that is more of an enforcement coupled with an audit in the sense of there's an investigation. I should have said investigation instead of enforcement.
Well, we have heard that from others who are directly navigating some of those COVID audits and the HRSA audits, that HRSA and the DOJ have said that they're just scratching the surface on those audits. So I think that we're still going to see a lot more of those.
What's interesting about this is we were talking throughout the conference for the three of us speaking, as well as for just attendees there, particularly those who've been in the laboratory industry for quite a long time. A phrase I kept hearing over and over again is everything that's old is new again. And much of it was in terms of there are a lot of new players in the laboratory industry. There's been a lot of turnover, but in particular during COVID, there were a lot of startup laboratories from people who had not been in the laboratory industry beforehand, many of whom hadn't even been in healthcare beforehand, and did not have experience with healthcare billing, and particularly not with laboratory billing. After the COVID testing subsided, although some of those went out of business, many of them shifted to other types of PCR testing. And so I think we still have a lot of players out there who they may be well-intentioned, but may not have the foundations in what is considered appropriate laboratory billing, what is medically necessary, what payers expect to see in order to reimburse for testing. Basically, what makes a test eligible for reimbursement by a third-party payer. It's not simply having a doctor order it. It goes much beyond that. And I believe that's also fueling a lot of these audits now, because when the payers are looking into some of these laboratories, they are indeed finding a relatively high level of what the payer would deem as non-compliance. And some of that may be imputed across the entire industry, when what we may be really looking at is this subset of people who are new to the laboratory industry.
I think that's a great point, Jane, because we see that a lot, even with our clients, the things that we're navigating. Like, I always revert back to pod labs, but when we get asked these questions, I'm like, really? Haven't we been there, done that? Don't we know the regulatory perspective on this? But then to your point, I think it is folks that are newer to the industry that just aren't aware of prior precedent, and they think that they've hatched this brainy idea, and we're like, nice try, but let me give you the legal perspective on this. So it is interesting that we're seeing this sort of resurgence of already settled issues.
I think that's absolutely accurate. Absolutely. It is interesting to see these things rise, come up again and sort of be repackaged in a new way. And as you said, Jane, I can remember, maybe 10 years ago, having those conversations saying, oh, this is, we're seeing this again, because there are new folks and they don't appreciate that this doesn't work from a regulatory standpoint. Emily used the example of pod labs. And here we are again in another cycle of that, where I think, again, folks are saying, oh my gosh, what a great idea. We can figure out how to set this up and make it easier for physician practices to be able to order testing. Well, there are ways to do it, but it is not without, some nuance. It's really important to be sensitive to that. And when you have folks that are just coming into the industry that may not be familiar with that history, it does seem like it repeats itself. Mm-hmm. So that's a really good point. And Jane, you kind of touched on some of the things that you did a really nice job of this when we were talking about it during one of the sessions, and just, an audit begins with a records request. And it's really important. I mean, a lot of times we are involved with providers that view sort of the audit process starting, or the need to involve attorneys or billing experts when they get a negative determination. But really stressing, I think you did a really nice job of stressing the recommendation that it's important to involve those billing experts or consultants or your counsel when you get the records request, because the first thing that's going to happen is you're going to submit that, and that is what the initial determination by the auditor is going to be based on, and you can't change that first impression. And to your point, Jane, really, when we see clients that only submit their own results and requisitions, payers are looking for more, and they really do want to see the records, the underlying records that prompted the ordering provider. I mean, that is what auditors are looking at as part of their analysis. And for better or worse, we all understand, and we have had to, we've made the arguments and we've supported the position that labs are not all knowing, and they don't have access to the patients. They don't have access always to the ordering provider's notes and those sorts of things. But that is part of what a lab has to navigate. That's part of doing business and, dealing with payer records requests and audits. So I think that's just an important note that I wanted to highlight, because you did a really nice job of walking through that when we were presenting on it. So.
Well, thank you. And for those who are listening who would like more information on the government investigations and payer audits, our colleague, Richard Blake, and I are going to be doing a presentation. It's a free webinar, co-hosted by McDonald Hopkins and the New York State Clinical Laboratory Association on Wednesday, June 18th. So if you go to our website, mcdonaldhopkins.com, or the NISCLA website, nyscla.com, you can register for the presentation. And again, we're going to be going over what you need to do in the event of a payer audit, as well as how to handle government investigations.
Thanks, Jane. I'm so glad you brought that up, because I had it in my notes to make sure that we covered that. And I think that will be a really robust and deep look at the themes that we're kind of covering at a high level here. So moving on and kind of rounding it out, I think there were a couple more themes that we were going to talk about. And one of those was the outlook on deals. So one of the big themes of the EWC each year usually is bringing together high-level strategic buyers, as well as, different folks that are interested in potentially selling their lab or their practice, as well as the advisors that are sort of involved in that process. And it's a very deep dive. It's the M&A workshop, and McDonald Hopkins is always involved in that. And so we really try to bring together the experts that folks want to hear from to talk about M&A activity and sort of what is the M&A outlook. So with that, I would say we also just wanted to briefly touch on the outlook on deals. So I don't know, Emily, if you want to kind of kick that off and just share some of the observations from the M&A workshop.
Sure. Yeah. So I think what we learned is deals are still happening. I think that there is a little bit slower coming to the table, especially on the part of private equity groups. I think there's a little bit more, I don't want to say due diligence, but more consideration of what the risk is in a transaction right now. But that said, the deals are still happening. So I don't think we've necessarily seen a slowdown in the occurrence of a closing of a deal itself. It's just more the progression of a deal might be a little bit slower. One of the themes that was focused on actually largely during the M&A panel was, since there were so many pathology groups there, was the concept of digital pathology and what sort of revenue that might drive for a pathology group that was looking to sell, and whether that was a necessity for maybe folks who don't have it. And then, we talk, as we usually do, about hospital outreach transactions. And we do see a fair amount of those going still. I think there was maybe a slowdown for a couple years where we didn't see as many. I mean, obviously everybody knows about the Ascension deal, and that gobbled up a lot of the outreach. But we still see, I mean, I know we have a few of those deals going on right now. So I think we still see a lot of that going on. And then we had really helpful perspective on the M&A panel from the Versant group on what to do when going to market and what buyers like to see, which I think was particularly interesting because a lot of the folks in the room are first-time sellers. So we walked through, like, what does a transaction look like, and when does that, dating process start, where buyers and sellers first get together and do their dance and then come to the table with an LOI. What does that look like, and how do you get to that point? So I thought it was pretty interesting. Crystal gave a really nice overview of some of the market considerations. And I think, the general uncertainty of stock market volatility coupled with a lack of transparency, maybe is a good way to describe it, into what the government is doing right now, has caused some trepidation. But certainly, as I previously stated, the deals are still happening.
I was just going to add, I think you sort of touched on this, Emily, but I think what we heard from buyers at all levels, whether you're talking about Versant or some of the larger national labs that are, considered sort of like the strategic, these are all considered sort of strategic buyers, depending on the potential practice or lab, was what are the differentiators? Sort of like, what's your core competency? What is your practice or your laboratory best at, and is that something that's complementary or accretive to the potential buyers? And I would say, I mean, I can think of a few transactions that are, moving ahead quickly, where, the clients are engaged in something that's sort of specialty, best in class, that sort of thing. So I think those in particular are, still in a really, they're moving along at what we would consider kind of the standard pace. And some of the other things that are still, they're very much of interest to the buyers, like you said, Emily, are progressing. But I think the financing and the uncertainty and all of those things are just causing the process to take longer, the decision making to take longer, like you said, the diligence to take longer. So
An interesting comment I heard from one observer was that he noticed an increase in the number of hallway conversations between potential buyers and sellers as compared to the last couple of years.
Oh, that's interesting.
Completely anecdotal, but it was an interesting observation.
Yeah, that's great. I mean, I will say, to that point, Jane, the hallways were buzzing. Obviously, everybody goes to the sessions, but the networking was pretty amazing. There was so much, I think, excitement. And obviously it was the 30th anniversary, but there was record-setting numbers of people there. And I just felt that people were connecting in a way that was more energizing than I've ever seen.
Agreed.
I think that's right. Well, I know we're getting to the end of our time, but I thought, one of the big overarching themes of 2024 was actually LDTs. And so that was something that we revisited again this year in a different sense because of sort of the timing of things that were happening. But Jane, I don't know if you want to touch on that just a little bit. I know we talked in our last episode about the decision that was specific to FDA's attempt, or FDA's rule, I should say, to oversee and manage LDTs. But I want to talk a little bit more about some of the, I guess, exit themes that we had from PwC.
And there were a couple of topics, on this topic, a couple of presentations on this topic at EWC, obviously planned well in advance of the court decision, which vacated the FDA's final rule, which was its attempt to regulate laboratory developed tests. Important to note is that the FDA has until Central Time midnight on May 30th to appeal the decision. As of when we're recording this, which is on May 21st, no appeal has been filed yet. Most observers do not think the FDA will appeal that decision, but again, it still has until Central Time midnight on the 30th to do so. Importantly, the court vacated the final rule but remanded it back to the Secretary of Health and Human Services for reconsideration. So most observers do think at some point when the FDA regroups, obviously there's a lot of turmoil in federal agencies at the moment, but the FDA may come back, perhaps pushing a little bit more of the legislative, proposals that have gone on in the past. In the past we've had the vital, valid legislation and others. So it's not over with yet. And the other important point, a reminder that was given during the EWC, was that the court's decision vacating the final rule does not mean that the FDA cannot regulate laboratory tests. This was a very narrow ruling that the FDA's final rule regulating laboratory developed tests was overly broad. But for any tests that are already subject to or in the future go through an FDA approval process are obviously subject to FDA. FDA still asserts that it has the authority to regulate other aspects of laboratory testing, such as certain direct-to-consumer testing, the sale of reagents as RUOs. So there are areas where laboratories still need to be cautious to ensure that they're not crossing over FDA guidelines.
I just want to thank you both for all of your your insights throughout this, and just sort of the overview that we were able to give of the EWC of 2025. So as always, if you'd like more information or you have any questions based on this discussion, please visit us at McDonaldHopkins.com. And if you have any questions or thoughts on future topics, we're always interested to hear what folks might be thinking about in the industry. So again, thank you both for joining us, and thanks to everyone who tuned in or viewed this.